session, we'll tell you how you need to approach that along with the explanation. So I'll appreciate if each one of you participate to evaluate and boost the performance. So today, as a organizer, we have with us Hema. She is an advocate and founder at Connect. So I welcome you again. Am I audible?
Yes, yes, yes.
Okay. So I welcome you, ma'am, and also one announcement that in the end of the session, we discuss about our UGC Net Law course at Law Seco. So stay tuned with us regarding that. Also, if anybody would be having doubt, we'll take that particular doubt in the end of our session today. So, and I'm excited. Ma'am, please let us know what all are the rules and regulations. So yeah, let's begin with our line of session.
All right. Thank you, Anup. I'm excited to be here again. We did international environmental law the last time, and today we'll be dealing with the Constitution and the legal framework for the protection of environment in India. And okay, I'll be sharing my screen. I have a couple of questions from the past year papers that we'll be doing, and yeah, let's get right to it. Can you guys see my screen?
Yes, ma'am.
Okay, great. Okay, so the idea, at least in this particular context, is that every time you're preparing for NET for this particular topic, you'll have to remember a lot of acts, specifically because environmental law is a very vast area. And one advantage is probably that you'll have to not study everything in detail, but have an overview. At least that's what is reflected by the past year question papers. However, there are a lot of case laws that you'll have to remember. So I will every now and then, based on answers, probably give you some tricks that you can identify and use to remember stuff better. Okay, let's start with the first question. This is a very simple one. However, it was asked in the law paper. So yeah, here goes. Which one of the following statement is wrong? Every person enjoys the right to a wholesome environment, which is the facet of the right to life guaranteed under Article 21. The power conferred by Environmental Statute may be exercised only to advance environment protection, not for a purpose that would defeat the object of the law. Financial constraints of the government may be a reasonable factor to exonerate government or municipal bodies from performing its statutory liability. Fourth is the precautionary principle, which imposes onus of proof on the developer to show his or her action is environmentally benign.
Right. All right, participants. So we have started with the quiz, and please try to solve these questions. These are important. And yes, please write a question number, then write your particular answer. And we'll be providing 1 minute, right?
Yeah, let's go with 45 seconds because, I probably take like 15 seconds to read the question already. So.
All right. So, okay. So I've started your time. Thirty more seconds to go. All right, time's up.
Okay, the correct answer is 3. Here they're asking what statement is wrong, at least, considering basic ideas. Article 21 talks about right to life, and your right to environment is also a part of it. Then any power conferred cannot be used, to defeat the purpose of the law. And then when we come to the fourth one, precautionary principle basically talks about taking precautions. So anybody going to invest in any project has to take precautions to ensure that the project does not have a negative impact on the environment. So all these three are correct. And even if you reasonably look at it, can the government say that it is okay for us to harm the environment because they don't have money? No, they can't. So here in this particular case, financial constraint is not a reasonable factor. So that is the correct answer. Okay, we have another simple question. This was again a question in the June 2019 question paper. Right to environment discourse includes right to health, right to sanitation, right to clean technology, and right to free speech. It's a pretty obvious question. I hope I'll get a right answer.
Okay, we have started with the timing. Participants, those who have joined the session, please try to answer because these quizzes are for you only. Fifteen more seconds to go. And time's up.
All right. The correct answer is 1. So when we talk about right to environment, you must know just understanding generally your health is impacted by pollution. Cleanliness is relevant to sanitation. Clean technology is basically the use of renewable energy so that lesser pollution is caused due to the use of fossil fuels. And if you have studied a bit of Constitution, right to free speech is under Article 19, Clause 1, Clause A. So in this particular context, we would only consider option A, B, and C, that is a part of right to environment and not free speech. So pretty obvious. Okay. Before this, I'd like to give a little bit of introduction in terms of Constitution. These are two very important articles, Article 48A and 51A. 48A is a part of the directive principles of state policy, which imposes a duty to protect the environment and safeguard wildlife and forests. So it is based on this particular duty. We basically have a lot of legislations that came into place. I will refer to this again sometime later, but this came into being in 1976 through the 42nd Amendment to the Constitution. We all know Article 51A talks about fundamental duties. So we're looking at this fundamental duty of every citizen to ensure protection of the natural environment and also improve it. So it basically talks about how, what environment includes. It's just not like forests, lakes, and rivers, but in this protection, we are also looking at having compassion for other living creatures. So that is where we bring in the concept of wildlife and other plants as well. Okay, one particularly very important case law in this context, which laid down that right to environment is a part of right to life, is Subhash Kumar versus State of Bihar. This was in the year 1991. We'll get to the facts of the case a little later, but just know that this was the very first case that brought under the purview of right to life is the right to pollution-free environment. All right. Okay, we have another question here. The Supreme Court in which one of the following cases observed that the issue of pollution should not be resolved at the cost of poor people's livelihood. Option 1 is Indian Council for Enviro Legal Action versus Union of India. Option 2 is Municipal Council Ratlam versus Vardichand. Option 3 is MC Mehtha versus Union of India. Option 4 is TN Godavarman Thimmulpaad versus Union of India. This was again a question in the November 2017 paper. So, yeah.
Your time starts. This question is related to constitution. I believe that many of us are aware of this particular question. So try to answer. Five more seconds to go. And time's up.
Okay, we have answer 3, MC Mehtha versus Union of India. Okay, I'd like to, before going into anything, I'd like to give you one little tip in terms of preparation. I'd suggest you to list out a lot of MC Mehtha cases. When it comes to environmental law, you have a lot of cases that are just named MC Mehtha versus Union of India, but the subject matter of each case law is very, very different. Right now, at least by process of elimination, we can hear, at least after we go through all these cases at a later stage, you'll be able to identify that MC Mehtha versus Union of India is the only one left out for it to be the correct answer, because TN Godavarman case talks about forest, municipal council. Again, all of these talk about a different subject matter. So right now you'll have to do this. One thing you'll have to understand when it comes to UGC net is you'll have to know what the examiners think that you have to know. That is like a very important. So that is how you'll have to prepare yourselves. Anyways, getting back to MC Mehtha versus Union of India, this basically spoke about pollution, vehicular pollution in Delhi. A PIL was filed based on the articles, directive principles of state policy, and the government basically passed various orders, and passed continuous injunctions and asked the court to ensure that the pollution in Delhi is curbed. So based on the submissions made by the petitioners, the court ordered the use of, compressed natural gas over other fossil fuels. And it mandated that the use of, it started with the process of ensuring all the government vehicles did this, then mandated all the public transportations and specifically buses did this, and then mandated rickshaws. This was a phase-wise transition that was ensured. And while the case was filed in 1985, the final judgment came about in the year 2002. Okay, it is also important that we remember the years of the case, because according to the NET 2019 paper, you might have a question based on chronology of the judgments of the case. Another thing important was the fact that during this procedure, there was a committee established, Burelal Committee. What happened? The purpose of this committee was basically to look at how clean every type of fuel that is being used by vehicles is. It could be diesel and petrol and CNG. So they did a comparative analysis of how clean and how much pollution each of these fuel costs. So please remember this. This has also again appeared in one of the previous year question papers regarding what was the purpose behind setting up the Burelal Committee. Next, we have the Indian Council for Enviro Legal Action versus Union of India. This was in 1999. This was again related to, one of the first questions where we looked at financial constraints. What the government basically said, being respondents, is that, we didn't have, enough money to take care of issues. And when it comes, this also spoke about industries that are causing pollution and adopted polluters pay principle into the jurisprudence of India, environmental jurisprudence. Polluters pay principle is basically an international environmental law principle, but it became something enforceable through this particular judgment. And then after this was when there was an amendment that was made to the coastal regulation zone notification that was already in place by the Ministry of Environment. All right. Okay. Next question we have, under the Wildlife Protection Act, the boundary of a national park shall be made in one of the following ways. 1, by passing a resolution in the Parliament. 2, by passing a resolution in the legislature of the state. 3, by passing a resolution by both in the Parliament and the state legislature. 4, by passing a resolution in the municipal body and the state legislature.
Okay, time starts. Fifteen more seconds to go. And time's up.
All right. The correct answer is 2. That is by passing a resolution in the legislature of the state. Now, this is a very, it might seem a little tricky question because we are talking about setting up of national parks, and ideally we would generally think it would be something at a national level, so we might answer it the Parliament, but the law basically states that the state government does this job. So giving just a basic idea, there is a Wildlife Protection Act that came into being in 1972. And purpose is basically protection of wildlife and wild animals and birds and plants. Remember, it was, at least what I've observed is, when we talk about wildlife, we usually consider animals, but it also involves plants. Under this act, we only have 2 boards, one at the national level and the state level. What this particular question referred to section 35, which spoke about declaration of national parks, and this is particularly done by the state government, not the national government. All right. We have another question. This is again a tricky question. I hope you all get it right. The state is a trustee of all natural resources which are by nature meant for the public use and enjoyment, and that Indian legal system includes the Public Trust Doctrine as a part of its jurisprudence. The Supreme Court has observed this in Godavarman Thimmulpaad versus Union of India, Indian Council for Enviro Legal Action versus Union of India, MC Mehtha versus Union of India, Sachidananda Pandey versus State of West Bengal.
Okay, your time starts now. So we are getting some response from some of our attendees. Jagannath, Tejaswini, Anand, Komal Agrawal. Yeah, please try to answer. Fifteen more seconds to go. And time's up.
All right, the correct answer is Godavarman Thimmulpaad versus Union of India. Okay, this is again a very tricky question, because if you do go through cases, and even on Google, if you type Public Trust Doctrine in India, the first case you will get is MC Mehtha versus Kamal Nath. This was the first landmark case that spoke about the Public Trust Doctrine. It is also called the Span Motels case. However, this particular doctrine was endorsed again in the case of Godavarman Thimmulpaad. So you'll have to remember, since the options did not provide for MC Mehtha versus Kamal Nath, identifying or while you're preparing, identify which doctrines were endorsed again or which cases were endorsed again in a subsequent case. That will become very important to answer questions like these. Again, just going through the rest of the cases that were mentioned, the first principle where we spoke about this case again spoke about this, Ratlam Municipal Corporation versus Vardichand. Here, the government said that, they don't have funds. So the court held that the plea for lack of fund is a very poor alibi. So if they do not perform their duties that are provided in the directive principles or whatever is stated in the act, they will be liable to face a penalty based on, whatever act or constitutional provisions they are violating. Now, Godavarman Thimmulpaad is basically talking about livelihood of forest dwellers in the Nilgiri region. And this was basically looking at the forests were being destroyed and what are the forest dwellers going to do, because their livelihood dependent on the forest. So the court gave a lot of directions and also set up CAMPA. This is very important. It's the Compensatory Afforestation Funds Management and Planning Authority. So just to ensure, looking at, the amount of deforestation that was happening across the country, and especially in this particular case, the court decided to ensure that afforestation practices became a norm, or the practice is mainstreamed. And then it also looked at people whoever suffered because of deforestation that is happening. They all have to be compensated, like, for example, forest dwellers whose livelihood is affected. So then when they lose their livelihood, they need to be compensated. That is what the court said in this. Next, we have Tarun Bhagat Sangh versus Union of India. This was again in 1991. Mining activities were happening inside a wildlife sanctuary. So basically, this was impacting the environment. The court said all the mining activities that are happening inside the sanctuary must be banned. All right. Okay. We have another question. Let's quickly.
Ma'am, what was the correct option of last question? Previous question. Option 1. Okay.
That's option 1.
Okay.
Okay.
Thank you, ma'am.
Okay.
Yeah.
Which of the following do not come under the powers and functions of the Central Board as provided in Air Prevention and Control of Pollution Act 1981? We have planning and execution of National Program for Prevention, Control and Abatement of Air Pollution, coordinating activities of state boards and resolving disputes among them, fixing standards of quality of air, making recommendations to the state government for the removal of state board, which is defaulted in discharging its duties under that.
Okay, your time starts now. $15 more seconds to go. And time's up.
All right. The correct answer is 4. We are basically trying to identify what is not the function of the Central Board. Okay. I'll get to this a little bit later. There's another question that is dealing with this. But yes. Here, what you must identify is that this under the Air Pollution and Prevention Act, Control of Pollution Act, we're basically looking at 2 boards that are set up at the central level and the state level. And the same boards are the authorities under both Air Act and the Water Act. So air pollution and water pollution both fall under the purview of this. When you're looking at least trying to answer this question, you have to ensure that it is reasonable when you're looking at the functions. When you're talking about removal of state board, it is basically removal of an authority that is established by a legislation. So it does not absolutely make sense that the function of a central board is to make recommendations in doing so. So ideally, even I'm talking about logic, answer 4 would be the correct answer. Okay, next. In which of the following cases, which of the following case the
Question 7.
Of India held that right to access to drinking water is a fundamental right to fundamental to life, and it is duty of the state under Article 21 to provide clean drinking water to its citizens. Question 1, Vellore Citizens Welfare Forum versus Union of India. Question 2, AP Pollution Control Board versus MV Naidu. Option 3, MC Mehtha versus Union of India, and option 4, Karnataka Industrial Area Development Board versus Shri C. Kenchappa. This was a question in July 2018.
Okay, time has been started. $15 more seconds to go. And time's up.
All right. The correct answer is 2. That is AP Pollution Control Board versus MV Naidu. I'll be dealing with this particular case a little later. I just want keep this case in mind and at least the context so that you'll be able to answer a couple of other questions. Okay?
Right.
Now, we have assertion and reason statements. This is basically something very logical, not very law related, but this was asked in the question paper. Assertion is the government could not control pollution in spite of continuous environmental monitoring system introduced in 2014. Reason is that environment related data, especially on the performance of polluters, have always been both limited in scope and invisible to the public. Okay, of course, assertion is true, reason is false. Assertion and reason are true, reason is not the correct explanation, assertion and reason are incorrect, and assertion and reason are true, and R is the correct explanation.
Yes, participants try to answer. Your time has already started. Five more seconds to go. And stop.
I'm sorry, just 1 second.
Yes, ma'am.
Yeah, the correct answer is 4.
Ma'am, we cannot see your screen, I guess.
Oh, sorry. Let me just... Apologies, there was some issue. Can you guys see it now?
Yes. Yes, ma'am.
Okay,
So
the
what is the correct
is
option? Okay.
Both A and R are true, and R is the correct explanation of A. This system was introduced by the government just to look at, identify how much pollution is happening because of whom and whom to control. But what happened is that the polluters themselves don't have any data out, or neither are they willing to give out data. So this was basically a factual related question, but yeah, it was there in the exam last time. Okay. Next question, Code of Criminal Procedure, which contains sections, some general provisions to cover ordinary situations, came to be regarded as an instrument to combat pollution in 1980s and was utilized in which one of the following cases? AP State Pollution Control Board versus MV Naidu, Charan Lal Sahu versus Union of India, Municipal Council Ratlam versus Vardichand, Subhash Kumar versus State of Bihar.
Okay, time starts.
At least 2 cases previously, so
Participants try to answer. 15 more seconds to go. And time's up.
okay, the correct answer is 1, AP State Pollution Control Board versus MV Naidu. Okay, before we get to that, this was basically again, process of elimination, because identifying which particular criminal law, at least when you're studying environmental law, going into depth of the judgment would be really difficult. So knowing the facts will definitely help you at least contextualize what the case could, be about. Before we go to AP pollution case, important is Charan Lal Sahu versus Union of India. What happened is, after the Bhopal gas tragedy, because the court thought that there were, thousands of people who were impacted and they deserved compensation. This was because of the negligence of the company. Basically, the government said, you don't have to file a case, we will do that on your behalf. And this procedure came into being through, Bhopal Gas Disaster Processing of Claims Act in 1985 itself. Now, what the petitioner did is challenge the validity of the act, because it is basically denying him of the right to make a claim separately. And the Supreme Court basically held the act is totally valid, and state had taken an exclusive right. This was basically to ensure that there is no multiplicity of cases, and then there were a lot of poor and illiterate victims who probably cannot file for claims through any other lawyers. And it basically looks at, in terms of making a claim against the company through civil liability and not imposition of criminal liability. So based on these particular reasons, the court held that the act here was valid and dismissed the petition that was filed by Charan Lal Sahu. All right. Okay. We have another question. Regulation of access to biological diversity is described under which one of the following chapters of the Biological Diversity Act 2002? Chapter 1, Chapter 2, Chapter 3, Chapter 4.
Yes, time has started. 5 more seconds. And time's up.
Okay, it is chapter 2. That's the correct answer. Now, just giving you a little bit context about the Biological Diversity Act of 2002. 3 things basically look at this purpose here and 3 levels: conservation of biological diversity, sustainable use, and fair and equitable sharing of the benefits. Okay, starts with conservation, then how do we use it, and then whatever benefits we receive out of the use that we have, we are looking at. This is basically what the act is regulating. Now, why this act came into place is at the international level, a convention on biological diversity was signed in the year 1992, and India became a signatory. So it was mandated after becoming a signatory to come up or implement an act, legislation in this particular context. Now, under the Biological Diversity Act, we have 3 levels of authorities. Remember, at least in terms of understanding the questions, just in case the people who prepare questions want to make it tricky, it's the National Biodiversity Authority, the State Biodiversity Board, and the Biodiversity Management Committee. At the national level, it is called an authority. At the state level, it is called a board. And the lower level, this is basically at the district level, it is called a committee. So when we talk, if the question just mentions biodiversity authority without the words national or the state, you must understand authority refers to the national level. The same way, board refers to the state level. And just have an idea about the structure or the arrangement of sections within the particular act. This is what I was asked. The second one basically talks about regulation of access to biological diversity. So, okay, I will go to the next question.
Yes.
Now we have this question which says the NGT Act 2010 contains how many schedules? 1, 2, 3, 4.
Right, time started. This is the very basic question, I believe. So,
yes. And this was also asked in June 2019.
Right. Okay, time's up. I've just given 30 seconds for this.
Correct answer is 3. Okay, just giving you a basic idea about the National Green Tribunal Act. The purpose behind this act, before they looked at why we need to look at environment and all, it basically looks at protection and conservation of environment that came at the international level. Firstly is the Stockholm Declaration of 1972. Secondly, we have the Rio Declaration 1992. And then they also relied on the cases that basically included right to environment and under right to life. Giving these reasons that, India is a signatory of all these international conventions, and also the fact that the judiciary has recognized right to environment, we are coming up with setting up an exclusive tribunal to deal with environment-related cases. And when we're looking into the jurisdiction, just the important 2 sections is section 14 and 15, which looks at settlement of disputes and giving out relief, compensation, and restitution. Restitution basically looks at restoring the environment to whatever situation it was before any project took place in that particular area. Again, according to the answer, there are 3 schedules in this act, but what is the important thing that you'll have to remember is Schedule 1. It basically lists out a variety of environment-related legislations under which for which the tribunal has the jurisdiction. Okay. I mean, even if you're going to study, prepare what are the acts you need to study for understanding legal framework of environmental law for UGC Net, please ensure that you have a look at all these, at least the chapter headings and the important provisions in terms of constitution and what the functions of boards in the Pollution Act are, or under the Forest Conservation Act, what are the authorities, and a Biological Diversity Act and Environment Protection Act, of course, which basically looks at, you know, a variety of other notifications that comes under the purview of environment, all comes through Section 3 of Environment Protection Act. So having an idea about all these 7 acts, I feel is very important, at least a basic overview. Okay.
Right.
This is a very, I mean, again, difficult question, I believe, but this was asked in December 2019. You'll have to arrange these 4 notifications under the Environment Protection Act based on years that they came into existence. We have Coastal Regulation Zone, Environment Auditing, Environment Impact Assessment, and Dumping and Disposal of Fly Ash. Can we give them a minute for this?
Right.
Oops. So.
Okay, time has been started.
If somebody can answer which years they came into being, I think that would help.
Ten more seconds to go. And time's up.
All right. The correct answer is 1. Let me just get to this here. Okay. Like I said, under the Environment Protection Act, by virtue of powers and under Section 3, the Ministry of Environment usually comes up with notifications for the protection of environment, and these 4 are a couple of important notifications. The Coastal Regulation Zone notification, basically to protect the coastal environment. However, there has been a recent amendment in the year 2018. So these regulations or notifications were, at least based on the answer key, were arranged based on when it was initially notified, not the amended one, but the initial notification. Secondly, we have environmental auditing that needs to be done, a notification that came into being that every industry is supposed to come up with a report, environmental audit reports for all the operations on an annual basis. Now, talking about environment impact assessment, 1994 was when the initial impact assessment notification came into being. 2006, this was completely repealed, and then we have a new environment impact assessment notification, because pursuant to 1994, this concept, they did not include public hearing at all. So to include a lot of amendments and new concepts, a 2006 notification came into being. And right now, if you have been following the news, there has been a proposal for coming up with a new notification for EIA 2020, which will repeal the 2006 notification. However, because of objections, it has been put to halt, but it would be ideal, at least in terms of being prepared for the December examination, to know what is the status of the EIA 2020 notification as well. Then you have dumping and disposal of fly ash, 1999. basically, when fly ash is being produced, what are the environmental concerns and how we can use it instead of just letting it pollute the environment. That was the notification, and this came in the year 1999. Okay, we have another question about Pollution Control Board. I'm hoping you can answer this. We have, which one of the following is not the function of the previous question we dealt with was on air pollution. This is the Water Act. To advise the central government on any matter concerning prevention and control of water pollution, coordinate activities of the state board and resolve disputes among them. To provide as technical assistance and guidance to the state boards, carry out and sponsor investigations, research relating to problems of water pollution and prevention, control and abatement of water pollution. 4, you have to advise the state government on any matter concerning prevention, control and abatement of water pollution.
Yeah, time is already running.
Please think about this very logically, and I'm hoping you'll get the right answer.
Five more seconds. And time's up.
I'm sorry, just give me 1 second. There's some issue with the...
Yes, ma'am.
Can you guys see?
Yes.
Yeah. Okay. The correct answer is 4.
Okay.
That is basically to advise the state government on any matter concerning the prevention, control or abatement of water pollution. So we're basically talking about the central board here. The previous question spoke about central board removing the state board, another authority. That was wrong. Here it is again looking at what is not the function. The role of the state board is to work with the state government, and it is not the function of the central board. So, just be logical about questions like these. It will be very easy for you to identify what is not the function. All right.
Right.
Just giving you a basic about what these functions are. We have functions of the Central Pollution Control Board and the State Board. These functions are exactly the same as present in both the Air Act and the Water Act. You'll just have to read through what they are, have an idea about what the Central Board does. Whatever is not included in the Central Board does it with the central government is what the State Board does with the state government. So you'll have to look at it like that. Okay, this is section 16 and 17 of the Water Act.
Right.
All right. We have a latest question. This was June 2019 based on environment impact assessment. This is pretty difficult because these are not very, very popular cases in the context of environment, but very important to know about. Decision-making process of those authorities, besides being transparent, must result in a reasoned conclusion which is reflective of due application of mind to the diverse concerns arising from a project such as the present. Now, difficult question because it does not even mention about the project, just gives the statement right of the judgment. So you have 4 options. Utkarsh Mandal versus Union of India, Deepak Kumar versus State of Haryana, Gram Panchayat Navla Kumbre versus Union of India, Tehri Band Virodhi Sangharsh Samiti versus State of Uttar Pradesh.
Okay, time starts. Few more seconds to go. And time's up.
All right. Okay, what's happening? The correct answer is 3. That is basically Gram Panchayat Navla Kumbre versus Union of India. Let's just have a look at all the cases. This is all again, all the cases are regarding environment impact assessment in Utkarsh Mandal versus Union of India. This was at the Delhi High Court. Basically looked at the procedural proprietary that was given. You don't have to remember the name of the industries that were involved. Just understand the concept that was dealt with. Here they were looking at the procedural law. What happened was we're looking at principles of natural justice. Nobody can be a judge in their own cause. So in this particular case, environment assessment committee that is set up to look at for the clearance. It was chaired by the person who already was the director of 4 mining companies for which the clearance was supposed to be granted. And in terms of, renewal of mining lease in this particular context. So because he was not the right person to be a judge in this particular case, the procedure that was adopted was questioned. Secondly, the answer for this question, Gram Panchayat Navlak Umbre versus Union of India. This was in 2012. A public interest litigation was filed by the Gram Panchayat itself against the government for the grant of environmental clearance. There was this company and environment clearance was granted. They basically questioned the grant of environment clearance here. And then while discussing this particular case, the court discussed the principle of sustainable development, looking at the amount of resources that is being used by the present generation. And it's, held that the resources must be utilized in such a manner that resources are left for the future generations to use as well. So please remember, even otherwise in the context of environment impact assessment, although the grant of environment clearance here was challenged, this could also be a case where you probably might get a question stating that identify the case in which principle of sustainable development was discussed, then it would again be this case. Then we have Deepak Kumar versus State of Haryana. Again, this is again mining. Government of Haryana gave a lot of auction notices. EIA notification in 2006 said you don't need environment clearance. However, because this was happening on the river beds of Yamuna and a lot of other rivers, and mining had to happen on these riverbeds, the court held that even though the law says so, for this particular mining auctions, environment clearance becomes mandatory. So despite whatever the law says, the court said environment clearance becomes mandatory because of the peculiar case of the fact that these mining leases were supposed to be granted for the mining on riverbeds. Next, we have Theriban Virod Sangharsh Samiti. This is basically Teri hydropower project was supposed to be implemented, and the public interest litigation again against this project. They said that the project did not include safety standards and it was not considered at all. There was threat to life and environment is going to be negatively impacted, and dams usually are considered a reason for earthquakes. But then the court held that government has applied its mind and approved the construction of the Teri Dam. All right. So, okay, we have the last question. I hope you guys can answer at least one of these and match the following. This was again in December 2019. We have 2 lists. exemplary damages, evaluation of cleanliness of various fuels, public trust doctrine, and right of each generation to benefit from past generation to preserve such heritage for the future. On the list right side, we have MC Mehtha versus Kamal Nath, Sterlite Industries, Intergenerational Equity, and Burulal Committee. Can we give them 1 minute?
Yeah, sure. Yeah, the time has started. This is the last question. Attendees, please try to solve it. Okay, few more seconds to go. 10 seconds. 5 seconds. And time's up.
All right. The answer is 2. Okay. List A on list 1, exemplary damages matches with Sterlite Industries. I'll get to this right now, just after this. B, we discussed this. Evaluation of cleanliness of various fuels. This was a part of MC Mehtha versus Union of India case, vehicular pollution, where Burulal Committee was established to look into this evaluation. So B is 4. C is the public trust doctrine, like I mentioned. MC Mehtha versus Kamal Nath or the Span Motors case dealt with the public trust doctrine, but T and Godavarman Thimmulpaad basically looked into or endorsed this particular doctrine. And 4, we have right of each generation to benefit from the past generation to preserve such heritage for future is the intergenerational equity. Okay, just the last part, Sterlite Industries. You might have seen this in the news against Sterlite. There was a huge protest in Tuticorin, and this case went. So what basically happened is the industry functioned without a proper environmental clearance. So the Supreme Court held that due to the functioning without environment clearance and the fact that the industry caused a lot of pollution and damage to the environment, specifically from the years 1997 to 2012. That's a very long period of time. Damages for all the people who suffered because of this pollution, damages were supposed to be paid, and this was exemplary in nature, and this was at the cost of 100 crores. So this is the particular case, and this was held in the year 2013. But just to conclude, I mean, at least I've exhaustively covered all the previous year questions in the past 5 UGC NET exams right now. These are all the questions, but in terms of preparation, I believe you'll have to cover a wider area. There are some concepts, at least whatever you find under Schedule 1 of the NGT Act, have a look at all the base overview of all these acts, and including that would be, apart from that, I would suggest you include the Wildlife Act 1972. And the landmark cases, there are, you might have observed that MC Mehtha cases repeats every now and then. So it would be ideal for you to identify which year's MC Mehtha case talks about which context, because it's all MC Mehtha versus Union of India. You might get confused. The years will represent which case they're basically talking about. Is it about pollution? Or if we have again a case on Taj Mahal, we have on public trust doctrine. So year and context for MC Mehtha cases becomes very important. So that is all for now. I think I'll stop.
Right. So thank you for organizing such a wonderful quiz with us. Also, participants, I thank you for joining this quiz. And now the session is open for Q&A. If anybody has any question regarding the preparation and the syllabus, how to cover, and any question related to UGC, they can ask their questions. And later I'll announce our winners. So if anybody has any question, you can write in a chat box, Q&A, wherever you find it feasible. Okay, so no questions as of now. Now I'll announce our winner's name. So first of all, I'll appreciate some of my participants who were regular and patiently listening us. Anupriya, Jagannath, JS Pawar, Kaushiki, and Surbhi Tejaswini Anand. So thank you for listening us, of course. And today we have two winners with highest score. First is Jagannath, who stood at first position. So congratulations. And second, we have Tejaswini Anand. She stood at second position. So as of now, I have only two winners. So thank you again. Also, I'll ask the participants to rate this particular webinar from 1 to 10, 1 being the lowest and 10 being the highest. Please share your feedback with us. And Arpana ma'am, could you please tell something about your our course, UGC Net Law course?
Yeah, sure, Anu. Thank you, Anu, and thank you, Himavati, for the wonderful session. It was really very interesting and very informative. So basically, what I want to say that the next UGC Net examination is at our doors. It may be in December or January. Hopefully, it will be in December only. So for covering the syllabus and it is a vast syllabus, so that's why we are organizing these kind of webinars with Himavati ma'am and Arpita ma'am. So please attend these webinars and also join us in our course, because that will help you to cover all the important topics of the subject. And basically we can you get the basic idea about how examination is conducted and what type of questions are being asked, and accordingly you can plan your preparation. So this is all I want to say about our course. So thank you very much, and congratulations Jagannath and Tejaswani. You are very active, and thank you.
Yeah. So, Hema ma'am, if you wanted to add something in the end of the session, then we'll sign off.
Yeah, nothing. Just congratulations, Jagannath and Tejaswini. I'm hoping you can join us for another session sometime soon. All right. Thank you so much for having me. Bye-bye.
Yeah. So thank you, everyone. Thank you, participants, for your feedback. And now I'll sign off with